many of you came on the Sunday morning to discuss such an important issue. May I request our director, Mrs. Nandini Sahai, to kindly escort Honorable Justice Santosh Hegde to the dais. I would now like to request Mrs. Sahai to welcome the morning.
A very good morning to all of you, and it's so nice to see a whole lot of you here come to listen to Mr. Santosh Hegde. We are very thankful to Justice Hegde for coming here once again to speak on the bill. As we all know, Justice Santosh Hegde is the former Justice Supreme Court, former Lokayukta of Karnataka, and honorable member of Judge Lokpal's Bill Drafting Committee. He was here in April to deliver his first lecture on role of Lokayukta in good governance in our lecture series on good governance. He was also part of the brainstorming session on Lokayukta Goa's concerns. Justice Hegde was of the opinion that the first Goa Lokayukta bill was good, except for some shortcomings like lack of policing powers and powers of prosecution, which have now apparently been addressed in the new draft bill submitted to Mr. Digambar Kamath by the Law Commission. I hope all of you who have come here have read and come prepared with the provisions of the old and the new bill. I will just read out some of the salient features of the new draft bill, which are the Lokayukta will have a separate investigative wing, a prosecution wing, and a special court for trials. Investigations will have to be completed within 6 months and trials within a year. So cases will have to be disposed of in a maximum of 1.5 years. 3. Citizens' charters, this is the number 3 point, citizens' charters will be made mandatory and every government department will have to be regularly updated. If the Lokayukta feels there is an offence, the case will be tried in a special court. A separate chapter in the bill has been dedicated to dealing with false complaints, and punishment for the false complaints of perjury will be laid down in section 182 of IPC. Those found guilty can attract imprisonment of up to 3 years. The Lokayukta will be empowered to take actions against all functionaries, including Chief Minister, Ministers, MLAs, and all government servants, as well as office bearers of local bodies, municipalities, Zilla Parishads, Panchayats, cooperative societies, government companies, NGOs, and individuals getting grants of more than 1 lakh from government or foreign or public contributions. Clauses from the previous bill that have been excluded are the contentious clauses in the previous bill relating to Right to Information Act and contempt of court. The Lokayukta will only be able to refer contempt cases to the High Court of Bombay and Goa, but not punish contempt. And I just quote here from a report which Mr. Sri Ramakant Khalak, who is sitting here, made. I'm quoting from his report. As early as in 1966, an Administrative Reforms Commission headed by late Shri Morarji Desai had advocated setting up of a 2-tier machinery of ombudsmen, one at the central level and the other in states, for redressal of people's grievances against corrupt people in the government. Lokpal bills were introduced in the Parliament in 1968 and again in 2005. Odisha established a Lokayukta in 1970. Thereafter, several other states followed suit. Goa had its first commission under the Goa Public Men's Corruption Inquiries and Investigation Act 1988. The provisions of this act were analogous to the Lokayukta Act in several states. Government of India circulated model bills on Lokayukta and state vigilance commissions to all states. The Lokayukta Bill 2003 was introduced in the Goa Assembly in 2003. It was referred to Select Committee. It was finally passed by the Legislative Assembly of Goa in January 2007. The Governor of Goa reserved it for assent of the President, as the proposed legislation was within the ambit of entry number 45 of the concurrent list 3 of the 7th schedule of the Constitution of India. It was examined by the Ministry of Law, Home and Personal and Public Grievances, Government of India. These departments made their observations regarding certain provisions of bills passed by the House in the context of Prevention of Corruption Act 1988. the Delhi Special Police Establishment Act and Right to Information Act. These observations were considered by the government of Goa, and it was decided that in view of legal infirmities pointed out by the central government ministries, the bill should be withdrawn and replaced by a fresh bill. We are informed that this proposal could not materialize as the April 2011 session was engulfed in pandemonium in the House. This is thus the checkered history of the Lokayukta Bill of Goa. Quotation ended. There have been lots of concerns and skeptics on the intentions of Goa government with regards to the new bill and withdrawal of the old bill. Let me make it clear here that the International Center does not take a stand on either. We are here just to give a platform for a very neutral discussion, or a healthy discussion on the pros and cons of the proposed bill and the old bill and the new bill, whatever. It's a neutral platform that we're giving. I hope that we have a very successful meet here today and come up with some kind of conclusions which will take this whole thing forward. May I now please give the floor to Justice Santosh Hegde. Would you like to speak for President?
Good morning to you all. It is nice to see many people involved in the process of drafting a bill. Normally it is not the procedure at all. Nobody takes any interest in drafting a bill. Except the people concerned, the bureaucracy, the law commission, the members of parliament, who of course shout from the top of the voice that they are supreme and ultimately nobody else can say anything about the law which they make. I didn't believe in this at all, because in the Constitution of India, democracy, in the system we are following, there is nothing called supreme, except the Supreme Court is called the supreme, there is nothing else is supreme. I know, as far as making of law is concerned, it's the legislature which makes the law, because people can't make laws like many political leaders say that the laws can't be made in Maidans and morchas, and we all know law can be made within the four corners of the parliament or the state legislature, wherever it is. But the question is, after that, the law can still be challenged before a court of law, and the court of law can strike it down as being ultra vires of the Constitution. Therefore, Parliament is not supreme in that sense. And the system also, I like to say in the beginning itself, the legislative lawmaking system is such, as I have understood it, that when the government prepares a draft bill or a private member prepares a draft bill, a copy of which is given to all the members of the concerned house, be it the parliament or the legislature. According to my understanding, the member of that house, being only a representative of the people of India, is supposed to go to his constituency and discuss the contents of this bill with his constituents who are interested in knowing what exactly is happening. Then carry an opinion which he forms from the different opinion that he gathers from his constituents, discuss it in the parliament. He should be an active participant, whichever the bill, whether it refers to his constituency or it's an all India bill or a bill which doesn't refer to his constituents at all, but then he is a member of the law-making body. Therefore, he should participate. His only business is that. He has no other business. Except that now they have diverted it into either for influencing the bureaucracy for transfers, or the ministers influencing the ministers for transfers, or getting contracts and other things and all. Under the Constitution, the business of the elected representative is to represent his constituents in the assembly or the parliament. Beyond that, there is nothing. And they meet hardly for 60 days or 65 days in a year. Then they are supposed to come back to the Constitution. But that system is forgotten now. The ministry concerned drafts the bill. Maybe it goes to the law commission, we take their opinion. They put it in the website. Some interested people might download it and discuss it and by themselves, not with the help of their representatives. And our representatives don't even get in touch with us. Once they are elected, then we see them after during the next canvassing days only. Otherwise, we don't see it. It is in this context, for the first time, And All India agitation started that there should be a right to the people of India to make suggestions. I mean, maybe it started by a small group. It could be questioned whether that group really represents the civil society, or it is only 4 or 5 people who are doing it. Be that as it may, they are also members of the civil society. As we have seen, as has happened in Goa, in Lokpal bill also, the Jan Lokpal bill was drafted after seeing the draft bill of the Government of India of 2010, which was the 8th draft that was produced in nearly 44 years. Every time a bill is prepared, it's never even presented to the House. Maybe once it went to the Lok Sabha, then the House was dissolved, it never came back. For the 8th time, that bill was prepared in 2010. Some people saw that bill and they said, this is nothing. This is an eyewash. So let us draft one and discuss with the government. Not that we be given the right to go to Parliament and debate it there or vote it for it. No, that was not the intention at all. But some people who are elected representatives suddenly realize that their right or duty, I would call it more, is being usurped by somebody who is not an elected person. You would have all would have read it in the paper. One member of Parliament saying, who are you? Unelected, unelectable parents. Who are you to say this? We are the representatives. In reality, if you take the election watch for the period 2004-2009 Parliament, in the Lok Sabha, for the 5 years, out of 547 odd members of the Parliament, only 174 spoke for the entire 5 years. What is this talk saying? We are the ones, we will discuss, we will tell the government. If you are interested in making it, you would have met your constituents and discussed it. Therefore, let us not be under an illusion that the citizens of India who have been totally kept out of this process. No, our inputs are also as much necessary. Now the standing committee says, if you want, you can come before us and explain it to us. That concept of you have no voice in this and only an elected representative has his voice, I think is no more in this thing. Some people ought to have learned it long time back, they have learned it now at least. So we have an opportunity of discussing this bill. We have done it so far as Goa bill is concerned many times, and I have seen various versions that's come out. The Honorable Chairman of the Law Commission is here, and they have prepared a bill of 2011. And there is the original Goa Lokayukta bill of 2003. And there are others who have commented on both these bills. I've just done through it because I got the copies in the morning only. Let me tell you, I have said once before also, the Goa Lokayukta bill of 2003 is good.